Okay, so for this video, I want to talk with you about Delaware Certificate of Incorporations, right? So who needs to file this and why, right? So if you're thinking about setting up a Delaware corporate entity, in order to do so, you have to file a Certificate of Incorporation with the state. So this is the initial, the very first document that is filed with the state. And so the state uses this information to create your legal entity and add it to the corporate registrar, right? So when you file a certificate of incorporation, Delaware statute requires that certain elements be in there, and then there are other optional elements that you can include if you want to, but you don't necessarily have to. Now, depending on who the lawyer is that's setting these things up for you, or if you're doing it yourself, there's a lot of differing opinions about what elements should be included, what should be left out. So you'll find that Delaware has a standardized format which covers the bare minimum. I'll show you what that example looks like later. And then we'll also look at an example for Tesla, right? So we'll look at Tesla's amended and restated certificate of incorporation that is publicly available because it's an SEC company. So we're going to look at that just for comparison purposes. But so back to the basics. What's required in the certificate of incorporation? Well, we need to first reference is what's the law? What's the Delaware statute? So the requirements that we're looking at here can be found in Title 8, the Delaware Code, Section 102. So you don't have to take my word for this. You can Google that, and you'll see within the statutes all of the elements that we're going to talk about right now. So first one is obvious, right? The name of the corporation. Duh. Like you can't launch the entity without providing them the name. So you have the name of the corporation is first stated on the document. That's the desired name. They do have certain restrictions on what characters can be included and what cannot. So you can look at the statutes in a bit more detail to find those limitations. The other thing that is really important is they have a list of words that have to follow the name of the company in order to indicate that it's a corporation. So for example, Tesla Inc., right? INC. Inc. dictates or indicates that it is a corporate entity, right? So it's not an LLC, for example. So Inc. is the most popular one. You can write out the full corporation. There's a whole laundry list of other options that you can look at, but typically you just put INC. So Inc. means incorporated, it's a corporate entity. Done. Now, the second piece is the registered agent name and address within Delaware. So every entity in Delaware, just like any other state, needs a registered agent within that state's borders, right? So for service of process reasons, you need to have a registered agent appointed. That agent's name and address are available in a public database. In Delaware, they don't publish information on the owners, or any of the business activities or anything like that, but the registered agent name has to be publicly available. So the certificate of incorporation needs that registered agent name and address. That's got to be in there. Now, the third piece is nature of the business or purpose to be conducted or promoted through the business. So what they're asking there is, what are you going to run the company and do, right? So what are you doing with the business? Now, Delaware and a lot of states do this as well, is they allow you to have just kind of this broad mission statement, if you want to call it that. So typically the verbiage is the nature of the business to be conducted is for any and all lawful purposes or activities, right? Something to that effect. Basically what you're saying is this entity can do whatever it wants as long as it's within the bounds of the law, okay? The second piece, or sorry, not the second piece, the fourth piece is the number of authorized shares and classes of shares. Okay, so what are they asking here? So corporations, basically by default, the first step here is you have just general corporate stock, right? So you have one class of shares. It's corporate common stock. So common stock means you own equity and you have voting rights, okay? You can also have multiple different classes of shares within that bucket, and then you have preferred stock, right? So if you want to have preferred stock, you've got to have that listed. But generally speaking, when you have the very simple certificate of incorporation, you have just one class of common stock, and that's it. Now, name and mailing address of the incorporator. So incorporator is the person that is filing the documents to form the entity. Now, if a lawyer is doing this or you're using a third-party service provider, The incorporator can be that person, but they want to terminate the relationship as the incorporator as soon as possible. And so what that means is they'll file the document for you to get the thing set up and running, but then shortly thereafter, the company needs to appoint board members, it needs to issue stock to shareholders, and then start hiring the C-suite executives, right? So who are going to be the officers of the company. But again, initially the incorporator has got to be in there. Now, if the powers of the incorporator terminate immediately upon filing the certificate, then the certificate has to include the names and mailing addresses of those persons that are going to serve as the first initial board of directors, right? And this makes sense, right? So if what you're saying to Delaware is, okay, I'm going to let's say me, for example, I'm Jason, I'm the attorney, I'm filing this, but as soon as the document is filed, my role terminates immediately and I walk away from it. That's okay, but Delaware needs to now know who are going to be the directors, right? Because we have to know who the directors are. In this context, most of the time you don't put that information in there because you don't want the initial directors to be listed because perhaps you might not know who they are going to be. And again, it's an anonymity issue. Maybe initially you don't want the state to know who the directors are going to be of the company. So, but in most cases you don't do that. Most cases you just have the incorporator file the document, get that on file, and then the incorporator takes the steps following that to have, appoint the board members, or the initial directors rather, and then the directors take it from there. So as soon as those first directors are assigned by the incorporator, then the incorporator resigns and the directors carry on the rest of the business that is necessary. Now, what is some optional information? Well, optional information, and this is also included within the title there in Section 102, we have provisions for the management of the business. So most corporations are governed by their bylaws, but if you want to include certain management provisions directly in the certificate of incorporation, you can do that. There can be provisions added for limiting the duration of the company's existence. So corporations by default generally have a perpetual existence unless you specify otherwise. So normally when you form a corporation, if the directors die, if the shareholders die, the company lives on, right? It has its own existence. But you can have provisions in there that say, well, given one of these contingencies, the company might cease to exist. You can do that. Okay, then last one here, we have provision eliminating or limiting the personal liability of a director for breach of duty. Okay, so directors have a fiduciary duty, and that is generally to act in the best interests of the shareholders, right? So you got to run the business, for profit motive, try to deliver value to the shareholders. That's high level kind of what it is. Obviously, that's a much more complex subject, but the idea is that directors have this fiduciary duty under state statute, but you can enter provisions to try to limit it or scale it back within the confines of whatever the law is. You really can't eliminate it completely, but people do try to add those provisions in there to try to give the directors some liability protection in case something does go wrong. Okay, so now let's jump over to some examples here. Okay, here we go. So here, this is a sample certificate of incorporation that's directly on the Delaware website. So you can see up here we have State of Delaware Certificate of Incorporation for a stock corporation. The stock corporation, what they're after there is, this is a company that's going to have actual shareholders. Non-stock corporations are like the nonprofits, right? So a nonprofit is still a corporation under state law, but it's non-stock and that you don't have shareholders. All the money is just contained within the corporate entity, the non-for-profit corporate entity. And in the event the company is dissolved, all the funds have to be distributed to another charity, right? So there are no shareholders that can personally benefit from the operations of a nonprofit. So that's the difference between stock and non-stock corporations. Now, we can see some of the basics that we talked about, right? What's got to be in there? Name of the corporation, fill in the blank here. Registered office of the corporation and the registered agent of the corporation, right? Now, line item 3, remember, you got to state whatever the purpose is for forming the entity, what's going to be the business activities. The purpose is to engage in any lawful act or activity for which corporations may be organized under the general corporation law of Delaware. Okay, very, very broad, right? Now, line item 4 there, again, this is the total amount of stock we're going to be issuing. So how many shares and at what par value? Obviously, this is assuming it's just one class of stock, so one class of common stock, and that's it. If you have more classes or if you're offering preferred shares, then you're going to have to expand upon that article. You're going to have to add more articles. And then lastly, there we have the name and mailing address of the incorporator, right? So like I said, like the incorporator is the one that's filing this document initially, and then after it's filed, the incorporator will work with the directors to have them take over, and then the incorporator resigns. All right, so now let's go look at an example. Let's go look at Tesla's example here. Okay, so here's Tesla's example. This is the amended and restated certificate of incorporation. And again, this is all publicly available information. You go to the SEC website and find this. But notice how the format is a little different, and it obviously contains more information than in the standard one that we saw, the template online. But there are some consistencies here, right? So we got the name of the company, all right, company address in Article 2, registered agent. Article 3, the nature of the business is to engage in any lawful act or activity. So, Tesla went with the broad statement there. They didn't try to narrow in on we're just going to be a car company or an electric vehicle company. Any lawful activity. Now, in Article 4, this is really where it expands, right? So Tesla is issuing common stock, so 2.1 billion shares, right? 2 billion shares are going to be common stock with a par value of 0.001 cent. And then they've got 100 million shares of preferred stock out there. Okay, that's a lot of stock. And then there's additional provisions here on increase or decrease in authorized capital stock, more information on common stock and preferred. So again, like if you want to have these additional pieces as part of your company, you're going to have to include them, so they're optional in that regard. But if you're looking to just set up a very bare bones, simple corporation, you can just use the template that the Delaware Secretary of State has on their website, right? Okay, so now Article 5, general powers of the board. Here's some information on the number of directors that are required and what their terms are going to be. Again, this is all optional information. You don't need to have this in the corporate charter when you file it. But again, if you want this ingrained in the certificate of incorporation, you've got to have to include it. So this is, if you've got a much more complicated certificate of incorporation, this is generally where I would recommend you get an attorney. Obviously, I always recommend you get an attorney before you form any kind of entity. But if it comes down to this, and your certificate of incorporation is this complicated and lengthy, you probably want a lawyer to review it for you. Okay, so more information on removal and vacancies. And then let's see, what else we got here? So special meetings, notices, and then, okay, so here's that limitation on liability, right? So here's where they try to add provisions to limit the potential exposure for directors in the event they do breach their fiduciary duty owed to the company and the shareholders. Let's see, so Article 9, so yeah, more stuff. But yeah, the point is, look, if we go back here, this is what's required. This is the bare minimum to have in order to set up a corporation in Delaware. Obviously, if there's more pieces to your business that you want to be included in the initial certificate of incorporation, you can add additional articles and add more provisions. But okay, so that covers it. I've rambled on enough. Yeah, it can be both very easy and very complex to set up a company in Delaware, but I hope this was helpful, a little bit of a guide on what's required and what's optional. And of course, as always, I really appreciate you watching. And if you have any questions, leave a comment below, subscribe to the channel, do the whole nine. And I look